So here's what we have in this case. And I know that the court didn't appreciate it. Bias against women is endemic to America's institutions.
Did you just say I didn't appreciate something?
I'm sorry?
Did you just say I didn't appreciate something?
I don't know if that's what I said.
Hold on, I'll tell us. I'll check. So here's what we have in this case, and I know the court didn't appreciate it. Bias against women is endemic to America's institution.
Yeah, I'm getting
So
ready
what do
to,
I not appreciate?
I'm getting ready to tie in what the court didn't appreciate. I footnoted in my notice of battered spouse syndrome that it wasn't traditional battered spouse syndrome, because traditional is the woman is still in the home. In this case, she was not still in the home. All right? But bias against women is endemic to all our institutions. And what we have in the testimony of Justin Warren is my opportunity to show that that bias was at stake. And the court is prohibiting me from the granting of its motion in limine that the state filed from questioning Detective Warren.
I'm sorry, point out in my amended omnibus order where I said you may not do that.
You granted the state's motion and said that until such time as I show it is relevant.
So I didn't say no. I said any impeachment must
Correct.
be relevant and material.
Correct. And
Okay.
I have filed this clarification to show the court that it is both relevant and material, and that's why I cited this case law. I don't want to be in a position, Your Honor, where my cross-examination throughout the trial is methodically interrupted by either an objection from the state or we have to send the jury in and out on multiple occasions, because that's going to create, it's not only going to render my examination less effective, it's going to create animus. I don't know if the jury's animus, I don't know where it's going to be directed. I only know that I'm here with an obligation to defend Ms. Benefield to the best of my ability. And under the case law, such a cross-examination of the lead detective is clearly relevant and material. So I have filed this clarification so that we could get past that. That's the purpose of this. I attached to my motion an excerpt from the deposition of Detective Justin Warren, wherein he says all homicides are murders and all who kill are murderers. Now, to me, Your Honor, that is clearly a bias. And it makes me wonder what chance Ms. Benefield had in the mind of Detective Warren when he was already describing this as a murder less than 45 minutes after the shooting, when he was drawing up his first search warrant. That is indicative of bias. I am allowed to probe that detective on cross-examination to show that his decision was motivated by bias. Whether or not I'm successful is a separate collateral issue. That'll be up to the jury. But the court, nonetheless, provisionally granted the state's motion in limine. Again, I filed this clarification so that we could get past that, especially given the fact that self-defense is Ms. Benefield's defense. And if you have a lead detective saying that all homicides are murders, it's not only a complete misstatement of the law, but it clearly shows bias. According to him, The 90-year-old motorist who has a diabetic incident while he's driving his car and hits and kills a pedestrian is a murderer. And the fact of the matter is, under the law, that would be an excusable homicide, assuming no drugs or anything else was at play. The court is provisionally restricting me from questioning the detective about that. That shows bias. It's a fair inquiry on behalf of Ms. Benefield, and I should clearly be allowed to make that inquiry, and I think the court restricting me from doing it is an impermissible preclusion of Ms. Benefield's right of cross-examination. That's my position, Your Honor.
State?
Judge, I would just say this is not a motion to clarify. This is a motion to state everything I've already stated that the court has already ruled on, and I think your order is clear. Thank you.
Mr. Taylor, rebuttal?
No.
All right. After I reviewed the defendant's request for clarification of the court's amended omnibus order, I read it as a motion for rehearing. I reviewed it carefully to see if there was any legal points or factual points that weren't addressed or needed clarifying. I will note that the state had filed a motion for clarification, and as I reviewed my prior order, I did notice that I had neglected to put the actual legal ruling in and the basis for that. However, I've had a chance to review the amended omnibus order, and I don't think it needs clarification, and quite frankly, I think and I find that the request for clarification is really a motion for rehearing, and I'm going to deny it. All right, we have two things left. The jury questionnaires and the request for paralegal to remain at counsel table. But I have a plea at 11 o'clock. And I don't see, did Miss Glenn come in? Not yet? All right, I've got a plea at 11 o'clock, so I'll need to take a little bit of a break. I think it's negotiated. Are you covering?
No.
I don't even have the state here for it. All right, we'll just keep going.
Judge, I think there's a third issue,
Oh.
Unless perhaps I misunderstood the court's earlier response denying the proffer of the expert. I have also moved to exclude the amended discovery that they sent, designating Kimberly Griffin as an expert and her CPT notes and her testimony.
Did you file a motion? Did you file a motion?
With the response.
Oh, in the response.
Yes. And in the alternative, if the court did not grant it, I asked for a Daubert hearing. Now, my response was late because the state's amended discovery was late. My response was immediately following that. If the court doesn't have a copy, I'll share my copy as long as
Bear
Your
with
Honor-
me, and it might be in the court file too, but bear with me. Kelly had also